3:02 p.m. on Monday, January 13th, 2014. My name is David Pilpel, the chair. This is the Education, Outreach, and Training Committee of the Sunshine Ordinance Task Force, City and County of San Francisco. We'll take a roll call in a second. Just wanted to mention that Vice Chair of the Task Force, Louise Fisher, was appointed to the committee subsequent to the agenda being posted, so that's why she is to my right and to your left. Roll call, Mr. Clerk.
On the call the roll, Pilpel.
Present.
Pilpel present. David.
Present.
David present. Oka. Oka absent. Highland. Highland absent. Mr. Chairman, would you like to take a motion to excuse the... Oh, my apologies, that was just me. Fisher.
Present.
Fisher present.
Am I on? Is this thing on? Does it
We're
have
on.
to be? Present.
And our current process is that we don't do excused absences. If people are present, they're present. If they're absent, they're absent. So we don't do a motion to excuse. And we're not anticipating members Oka and Highland today. They were unavailable for today's meeting. So I was intending to take the items in the order presented. Any concerns? Seeing none? Okay, then we'll just proceed with the agenda as scheduled. So item number 2.
Item number 2, file number 12013, hearing on the determined violation of complaint by William Clark against Howard Lazar Arts Commission for allegedly not providing documents of expenses charged to the Street Artist Program for fiscal year 2010-2011.
Okay, so let me just introduce this briefly, and Mr. Clark and Mr. Lazar, if you're ready, there's some new information that we have in the packet starting on page 14, an email dated January 7th from Mr. Lazar with a letter dated January 7th that actually continues with the date of January 8th. That's fun. And the Arts Commission log and the City Attorney's log. So that is new. And there was some information previously about Admin Code Section 8.3-1 and other sections of the Admin Code. Other than that, it's the old material, and we've had this before us several times, so let's see if we've made sufficient progress and can conclude the matter, or if there's something else that we need to do. So with that introduction, Mr. Clark.
Hello, task force members. William Clark. I just want to let you know I'm still not satisfied with the response for 2 reasons. One, the main thing I'm asking for still wasn't responded to, and that was some sort of explanation or detailed analysis of what the advice on each Sunshine conference with the city attorney, what advice the city attorney gave to the department, and some sort of at least explanation of what was discussed during those conferences and what the outcome was. And I would just like to remind you that at the last meeting, you asked for the city attorney to have a representative here because they're still claiming that they're not going to release any more information because it's an attorney-client privilege, and they instructed Mr. Lazar not to release any information on what they discussed or what was involved, and you asked for Aideen Vera to be present here so she could defend the city attorney's position that they consider that all this information that I'm requesting is attorney-client privilege. And basically, like I said, in this new email, they had 3 new categories, which they listed REM or RAR, but it doesn't provide, and the log is great. I'm not knocking the log at all, other than what I would like to possibly see a category at the end that has the resolution of any complaints that were filed with the Sunshine Task Force. If this a request actually went to a complaint, I think that it should record what the end result of that complaint was, whether it was dismissed or whether they were found in violation, and what sections of the Sunshine Ordinance. And I think that that should be included in there, which would be great for the public. But like I said, my thing was that if there is a conference between the city attorney and regarding Sunshine, and there's some advice that was given, even though I know what the original request was, I still don't know what was discussed with the city, what issues were discussed, specific issues were discussed with the city attorney between the department and the city attorney's office, and what was the final advice or conclusion given to them. So as far as I'm concerned, unless I see a city attorney come here, I feel that the city attorney is willfully refusing to come here and answer your questions, provide you with, because you specifically asked them, you said that these things are clearly public records and information under the Sunshine Ordinance, and Mr. Lazar said that he was advised by the city attorney that their legal opinion was the opposite, and you asked for one of them to come here so they could give you their reasoning, their legal opinion of why they consider this attorney-client privilege. And so I just conclude by saying that I'm totally dissatisfied with this. It's been a whole year that I've been waiting that the task force found them in violation, even though I know there's been some reasonable reasons for continuances at the last meeting. I think we're getting closer to a resolution, and the main issue is that I still do not have any advice, and I'm seeing it as that the city attorney is refusing to put that advice there because perhaps they're advising them in ways and manners of how not to release this information. Because as of right now, we're entitled to know something, and obviously the city attorney is advising them not to release this information, and I see that as a willful violation of the Sunshine Ordinance for the city attorney to provide counseling to the department, to give them advice on how to refuse to release this information. So I would request that you send this back to the full task force to see with a finding of a willful violation to provide me with this information, and see what the full task force would like to do. Thank you.
Great. Thanks. Let's see. Are there any speakers in support of the complainant?
Hi, Robert Clark. Yes, because we do have a new member here, I really want to emphasize, and I'm sure the other members can do it too, that at the last meeting, we were emphatic. The committee, the task force was emphatic that a member of the city attorney's office be present, because the order of examination made it clear that information dealing with sunshine requests is public information. It's in the law, and the city attorney is basically just blatantly refusing to give that tell the Art Commission to release that information in the form of the way we've requested it, on the grounds that there's an attorney-client privilege. And we ended the last meeting with, well, there's really nothing we can do but get the city attorney here and try to have an honest dialogue with them. And Mr. Lazar did say that he would try to do the best. Now, I don't know if maybe that's a question you can ask Mr. Lazar. Did he even talk to the city attorney about coming here? Why isn't Ms. Vara here? And why isn't she? If she can't make it, why isn't there another member of the city attorney here? Because at this point, they're just stonewalling this, and because personally, I think it's been explicit by the law that we do have a right to this information because it's public, and the city attorney just doesn't like the Sunshine Law and is refusing to go by it, and they can't come in here and expose that, so what they do is that they don't show up. I'd like to know why there is no member of the city attorney here. Perhaps you can ask Ms. Patterson Murphy or Mr. Lazar why the city attorney isn't here. And if the city, there's no real reason why they aren't here, then I am also requesting this go back to the full task force with a willful violation, either on the part. I can't blame Mr. Lazar if he's standing here, just standing by his attorney's advice, but this is something that we were trying to get beyond so that we could hash out this last little bit of information that we want on those logs, which is something about the subject of the discussion and something about what the city attorney, what the conclusion was that the city attorney advised them, not on a massive scale, but just on some kind of a description, so we can determine whether we're being charged for something that is really relevant to the street arts program, or are we just having phony discussions to raise the amount of money that we have to pay to make it a hardship for us because we're confronting the city attorney.
Thank you. Ms. Tesh.
Hi, members of the Education and Outreach. I request also that you find a willful violation and send it back to the task force, simply because, and this is a typical, I wonder whether it's a tactic or there's something seriously wrong. Howard Lazar cannot seem to read and write, and that's a problem that comes across in almost every immediate disclosure request. He didn't even attempt to satisfy the Clark brothers' immediate disclosure request. They requested, what is the name of the city attorney on each of these? Can you mark that down? Can you mark how much time was spent on it? Can we have something that we can verify? And they got absolutely nothing. I want to put into the public record an email that I got from Lazar the day after the last EOT meeting, where he puts in, he recalls asking the committee members how long he had to endure listening at the meeting to my tedious, monotonous, ongoing diatribe against his alleged personal shortcomings, as this had nothing to do with the purpose of the hearing. I'm sorry, that was an agendized EOTC hearing that I had after the Clark brothers. It was my turn to speak under public comment. That speaks to the fact that not only is he willfully violated, he does it in writing. I also want to add into the public record an email unsolicited again I got from, what's her name, Kate Patterson, where they're constantly making mistakes. This one, I went up to pay for a permit. There was a sign on the door saying we're closed between these and these hours. That was not the case at all. And then I got this unsolicited email saying, we will email you in the manner we choose and to whom so we will like. We will not change our processes to accommodate you. That speaks to how they do their sunshine requests. And then I also want to add that it's not only in this specific immediate disclosure request that Lazar doesn't answer the questions. In this one, he claims he provided a JPEG email attachment with documents. He did not. And then comes Kate Patterson chiming in and saying, you altered public documents. They were sent to you. They were not. And then we come the next day with Howard Lazar saying, my apologies, I didn't add the JPEG thing, but it didn't matter since the documents were irrelevant. And it plays out over and over again, this forgetting of attaching the documents at least 5 separate times. And it goes over to this repetitive nature of Howard Lazar, which you see in almost everything he does. The repetitive emails I get from him, sometimes 15 of the same emails. It is enough to drive you up a wall. So here are some public things I'd like to enter into public record, and I request that you find a willful violation, send it back to the task force, because this is not a simple matter
Thank you.
of constructing a chart. Thank you.
Thank you. I'm not sure if those emails are particularly germane to this instant complaint, but we will put them in the file and review them in the fullness of time. Thank you. Are there any other speakers in support of the complainant on file 12013, item 2 on the agenda? Seeing none, let's hear from the respondent, Mr. Lazar, Ms. Patterson. Did I hear that there's a change to Ms. Patterson? Are we now a hyphenate or a two-word?
Or hyphenate.
Very good.
Mazel tov.
Congratulations. Mr. Lazar.
Yes, well, I sent you the letter, and because you had asked, how do we use our log? And I explained in the letter how we do use it, and gave a typical example of line number 39, which I won't take you through because it's already in there. If anything on this particular issue that was requested, if I had anything in writing now, to this day from the city attorney, I have no problem turning it over because it is a sunshine matter. The point is, I'm not so sure about conversation being taken over the phone, as a sunshine, that is sunshineable. And I think that goes to the heart of the request to the city attorney's office. I cannot speak on behalf of the city attorney as to whether or not Ms. Vera is here, what her reasons are for not being here. That's not up to me, and it wasn't even shared with me. I did talk. I asked them to be here. Okay, so I did my part. The point is, the letter that I had furnished, the response I had furnished, was what was dictated to me by the city attorney. I'm sure I wrote it down, but I don't have what I wrote down. I threw it out. That's about as good as it can get. If I'm not believed in that response, then I think they should just demand from the city attorney to see if that letter that I wrote is valid or invalid. And that's all I can really say. I can't produce a document that I don't have. And that's it.
Thank you. Any speakers in support? Ms. Patterson, and let's get it right now. It's now Patterson.
Patterson Murphy.
There we go. Thank you.
So I just wanted to say good afternoon first, and to just sort of reiterate and sort of recap our response to this matter from the beginning. We were not required to do so. However, we did in good faith create a new sunshine log to create a more accurate picture of complaints or questions and how we track them and how much time we spend on them and whether or not we do consult with the city attorney in order to provide the complainant with some sort of picture of the process. Additionally, I many months ago pursued a more detailed reporting from the city attorney's office. Again, I'm not required to do so. The city attorney did add more detail to the reporting. We have produced that. So I feel we have made a good faith effort to provide as comprehensive of a picture as we can with regard to sunshine requests. And I just want to say that between the log and our response to the complainant and the city attorney billing, one should be able to comprehend what the advice may or may not have been. As Howard said, many times we speak over the phone with the city attorney, and we do not have any written documents, which we would gladly turn over because we know those are sunshineable. But we do, I think that there's enough evidence of that the content of our conversations represented in the log, our actual response, and in the billing to surmise the conclusion, or what action we've decided to take with regard to that particular request. So I hope to see this matter concluded. This is, I think, our third or fourth hearing on the matter, and really, I think we're getting into sort of the excessive zone. So I hope that we can all reach a resolution today. Thanks.
Thank you. Are there any further speakers in support of the respondent? Seeing none, I believe the matter is with the committee for discussion and questions. I'm just reflecting on the excessive zone. Interesting concept. Member David.
Yeah. So, thank you, everyone, for coming today. Yes, we have heard this. I'm sorry?
Go ahead.
No, we have heard this this matter many times, and I want to thank everyone for their patience. I really think that this particular case really gets to the heart of a lot of the issues that we deal with on the task force. And so I want to really, my true appreciation to the Clarks and to Ms. Patterson Murphy and Mr. Lazar for your patience on this issue, because it is fairly complicated. No, I was not at the last education outreach. I was not able to make it the last minute. So, Mr. Lazar, could you please come to the microphone, because I have a quick question for you. The two education and outreach meetings ago, we had a conversation where, and it sounds, and maybe I'm misremembering, but it sounds like that perhaps your statements on what is sunshineable or not have evolved over the last two meetings. And that I felt like 2 meetings ago, you were perhaps saying that your city attorney was giving you advice that certain conversations that you had with the city attorney regarding sunshine issues were actually not necessarily, you didn't necessarily have to give that information over to the Clark brothers. And now and I want to make sure I'm hearing you correctly. Today you're saying that the advice from your city attorney is that if you had any documents referring to conversations about the Sunshine Ordinance, it is now your understanding that those documents are disclosable. Is that a fair?
That's my understanding, yes.
So there has been an evolution over the last couple of months. Is that a
Right.
fair?
The line of distinction between what is sunshineable, what is not.
Okay, fine. I just want to make sure that we're all, okay, so thank you. Mr. Clark, William Clark, would you please come up? I have a question for you. So I have been working, I was tasked to work on a letter to our city attorney asking for clarification on this very specific issue, right? What is disclosable, what is not disclosable, regarding conversations that department heads have with their city attorney around sunshine. In doing some research, one of the questions that I don't know has been asked is that, has this question been appealed to the supervisor of records? Not the custodian of records, the actual supervisor of records.
Right, the city attorney's office, you mean?
No, there's a specific position in the city attorney's office
Right.
under the Sunshine Ordinance that the person is the supervisor of records.
That's who I'm referring to. That's
Okay, I
that's
just
what-
wanna-
right.
so my
No, I
question-
haven't referred it to them.
Okay, thank you. That was what I wanted to know. So I have a suggestion that we, as the Education and Outreach Task Force Committee, write a letter to the supervisor of records asking for clarification on this very specific issue. When conversations take place between department heads and their city attorney on issues that are clearly about the Sunshine Ordinance, what is the appropriate amount of disclosure?
Okay. Let me,
Got people in the...
we'll take some further comments in a moment. Give us a chance here. Okay.
Member David.
Yeah, sure.
Let's get into this for a second. So the role of the city attorney generally is to advise departments and officers about their responsibilities. The role of the supervisor of records is only in the ordinance and is pretty clearly and narrowly circumscribed to responding to petitions as to whether or not a record is public and a department needs to provide it. So I think I would parse that a little bit and say that we could send a letter to the city attorney. Generally, I think if we send a letter to Paula Jessen, who's the supervisor of records, she will likely respond that she can't address that directly because that's not within her scope as the thing. I think as a task force or as this committee, we could ask the city attorney generally, and they can farm it out to whoever they choose to address this question. I think it's a good and timely question.
Okay, so let me just say that if we as a task force are not able to write a letter to this, Ms. Jessen, I would encourage the Clark brothers to, while whatever track this is going down regarding the Sunshine Ordinance Task Force, to simultaneously write a letter asking for clarification from the supervisor of records. If we cannot do it at the task force.
But we can to the city attorney, so if it doesn't go to her, it'll go to somebody else.
So as I was preparing my letter for the city attorney, this was an issue that came up in some conversations with people who understood the Sunshine Ordinance Task Force, and I thought it was actually very good advice. That either the Clark brothers do it, or if we as a subcommittee ask the. Okay. So anyway, I just wanted to.
Okay, so I wanted to do a couple of things, and noting that we have other people here and we've got some other stuff we got to do. The original complaint, let's remember that, was about the breakdown of and documentation for the 2010-11 fiscal year, which is now 2 years ago plus. So we got some information about that that's way buried in the packet here, page 77, etc. That was not as much information as we thought necessary. That was why we, as a task force, made the order that actually, as it turns out, none of the three of us joined in, but never mind. But we've been pursuing it nonetheless. I think what we have achieved is both the log from the Arts Commission, which did not exist before and has a certain amount of pretty good information, and we now have some new coding in the city attorney's office billing system on this issue, for which one can get both documents because they're both public, I believe, although the city attorney one is labeled attorney-client. But nevertheless, if one gets both of these, one can sort of interrelate the two and say, you know, on this date, for example, August 8th of 2013, well, all right, maybe it doesn't exactly track. I think the goal was so that you could look at the date, and the date on one where there was time spent with the city attorney would track to the city attorney's log. It doesn't quite get there, but I think maybe it's headed there. I would note, for whatever it's worth, on page 21 of the packet, the new city attorney log, we finally found the secret category of labeled description. However, it is blank for both of these listed items. So if we can further request of the city attorney where they have something descriptive that could go in the field description, that would be helpful. That might address some of the concerns about the type of advice, or, you know, I mean, yes, it's clearly showing the new category, public records, search, review, and/or response, but their description field could include something about the type of records that were being sought, or their conclusion, or something. So that's an opportunity for the city attorney to disclose what they feel they can disclose that is public, etc. So are we clear about where that is here? Does everyone see that? Page 21, the description field on the city attorney time record. So there's that piece. Again, as to the original 10-11 records, I think we sort of did all we could on that. If there's anything else that's germane, I'd love to hear about that, but I definitely would like to close that out as soon as possible. I think what we ended up doing here, which we're going to try not to do in the future, is to sort of expand the scope of an item. So I think that we need to close out the the complaint itself, and if it generates a further issue, as the next two items did, we're going to open a new file on the larger issue. That's my intention. I have no problem with sending a letter to the city attorney. I think this issue of what is public under, one second, I think it's, what, 24I, 21I? Somebody help me for a second. 21I. All right, anyway, you'll want to refer to that in the draft letter. So I have no problem supporting us sending a letter, you to prepare, me to send, hopefully city attorney to respond, and when we get a response to that, we will certainly share it. We've got no problem with that. Otherwise, I'm inclined to close this matter, but I'm still open.
Yeah, I just want to be clear that, like, I feel like everyone has been really good actors on both sides. That I feel like this is a legitimate, like, issue that is before the task force, that people of San Francisco need resolution on what is disclosable and what is not when the city attorney speaks with the department head. And I in no way feel that Mr. Lazar has been trying to hide. I feel like that they have gone out of their way to try to work with their city attorney and with the Clark brothers. And so I am in agreement with you that I would like to see this specific issue closed, but I don't want to see the larger issue. I want to make sure that we address the bigger issue at hand. It doesn't get kind of thrown away as we dispose of this particular issue.
That's fine.
So that's my only hesitation.
And we can do that. We can close this and open another thing. What do they say when one door closes? Another. Never mind. Okay, so that's kind of where I am.
Jump out the window.
Yes, if the window's open. Otherwise, Member Fisher.
Well, I guess I need a little more clarification. I'm the new guy on this committee here. So what I heard you say is remember, David, is some sort of methodology or whatever of how to capture the record or the information of when a department head talks to the city attorney.
Specifically about Sunshine Ordinance, compliance with the Sunshine Ordinance Task Force, right? Or the Brown Act or Freedom of, right? That is at the, to me, what this has done is distilled.
Written minutes or a sound recording?
That is the question at hand, right?
That's my question,
right?
too.
Right? We have a log that says that Howard Lazar has spoken with the city attorney for X amount of
0.25 hour was billed, right?
So, from the city attorney's point of view, I would actually argue from the supervisor of records point of view, what is the minimum amount that one needs to disclose about that conversation? Is writing, I spoke with the city attorney about Sunshine Ordinance Task Force, is that enough? Right, and I feel that at all the issues that what we've distilled this case down to is it's come down to that very specific question.
Okay.
And I think that it's a valuable question to ask.
So on that point, just for a moment, and then we'll move on, let's look at page 12 of the packet and read that particular section. Some of us have that, right? The San Francisco City Attorney's Office, this is 67.21I, the San Francisco City Attorney's Office shall act to protect and secure the rights of the people of San Francisco to access public information and public meetings, and shall not act as legal counsel for any city employee or any person having custody of a public record for purposes of denying access to the public. The city attorney may publish legal opinions in response to a request from any person as to whether a record or information is public. All communications with the city attorney's office with regard to this ordinance, including petitions, requests for opinion, and opinions, shall be public records. So that is kind of the section and the last sentence in particular. I would note that it says shall be public records and not public information, and there's a distinction in the definitions about public records versus public information. So, that suggests perhaps that if a record is created, that the record is public, but if it's a conversation of which no record is created, then maybe not. But I don't, it's a good question, and there is some ambiguity there. There's probably some clarification in the Good Government Guide, but we want some further explication on this issue because it is still there and ought to get some, light, air, heat, etc. So I'm in support of the letter and opening a new file on this, but I'd like to hear further as to whether there's anything on the instant complaint about 2010-11, and I've stated my inclination there. Member Fisher, are you good with that? Shall we go to further public comment?
Yeah, I can carry on.
Okay. So next is the respondent, Mr. Lazar, or Ms. Patterson, on clarification and rebuttal. And then we'll be back to Mr. Clark.
I would just say, this is Kate Patterson, I'm the Director of Communications for the San Francisco Arts Commission, that I think as it stands now, I think that the Arts Commission will rest from pursuing this matter further with the city attorney, and that should Mr. Clark or the Sunshine Task Force require further participation for them, we encourage you to continue with your plan to approach them and to encourage them to come and testify. But we feel like we've done our job as to the best that we can, and we can't force them to be here or respond in the way that you may want or Mr. Clark may want. So we're going to step out at this point and do what we can do. Of course, we'll be responsive to any requests that's come from you, or if there's any further sunshine requests with regard to this matter. I will just say that in our conversations with the city attorney, sometimes they may be conversations that are sunshine related, sometimes they may not.
Right.
And so I think one of the challenges is sort of parsing out, what kinds of information are exchanged during those conversations and how they're represented. Okay, thanks.
Appreciate that, and we'll try to tease that out in our letter. Mr. Clark.
Well, I have several things to address real fast here since I only have 3 more minutes. First of all, the information over the phone is public information. Whether or not any records were kept or not, what was discussed and what the outcome was is public information, which, as a member of the public, I'm still entitled to know what that public information was. And if the individual who spoke over the phone is present or at any time, they should be willing to either give me the information or tell me where to go to get it. Secondly, we're trying to settle future problems with this situation, and that's why the log was done as opposed to necessarily the past, and that's why I'm requesting that, since they claim that I should be able to do this, and that the information that they put in the log concerning what the public complaint was about or the request was about, I should be able to figure all this out by combining all these things, and that information is all there. Then they should be willing to include one thing at the end, just clarifying what the advice was, since they claim I should be able to easily, or Ms. Patterson claims that it should be very easy for me to figure out what advice the city attorney gave them and what they said. So I'm saying that even though they weren't required to do that, that's still available. I shouldn't have to try and figure all that out. Also, Howard made some comment about him maybe destroying a letter or something that was just that he did, and as far as I'm concerned, that's the destruction of a public record, which should not occur under any circumstances. And I may be wrong about this, but I do believe the Public Records Act does include a definition of what a public record is, and in that it includes public information as, technically a public record. It's not necessarily that it has has to be on a document, but it's information that a public officer has, which is available to the public. And, I don't feel that it's been settled that this issue of the attorney-client issue on this has been settled by this, and I would like that matter to be settled. And so all I'm saying is based on what I see there, I'm going to still have a difficult situation figuring out what was said between the two of them. And I think it's cavalier for her to say that we should easily be able to figure that out.
Okay. We'll comment on that in a moment. That was the rebuttal. It's now with the task force for a motion and deliberation. I would clarify slightly that the Public Records Act has a definition of public records. The Sunshine Ordinance has a definition of public information that refers to the information from a written record. I would be surprised to hear that an oral communication constitutes public information that must be disclosed. There is a requirement that each department head designate someone as their essentially public information officer or spokesperson for items for which there is no other specific individual, but they are limited to providing information that is gleaned from documents. So anyway, I think where we are on the motion, it sounds like Member David, did you want to make a further motion? I forget actually what we did last time on the letter. Do you want to make a motion to authorize sending the letter? Because I forget if we did that or not.
So, well, I don't believe, I have a draft of a letter.
That's fine.
That, that I'm willing to certainly share, and I think it needs some more, it needs some, working on, but it's basically what I'm looking for is the answer to the question that I've now said about 3 times.
Okay.
What is, yes, that information from a comment from the city attorney.
Understood.
Yes.
So
I don't know what kind of motion needs to be made to send a letter to the city attorney.
Victor, do you recall if we passed a motion to authorize a letter?
I do not know of a previous motion, but I believe there's a motion as before you today.
We certainly could.
Motion to write a letter to the city attorney for clarification as to what a public record is in regards to guidance between the departments and the city attorney. Conversations.
Around the Sunshine Ordinance task force. Around the Sunshine Ordinance, excuse me. Specifically, conversations regarding the Sunshine Ordinance.
Related to 67.21I,
21.
et cetera.
Yeah,
Okay.
yeah.
So I'll take that as a motion from Member David, second by Member Fisher.
Second.
Okay. And we'll do, Victor, should we do a separate
comment?
We'll do that before we go. Should we do a separate motion to conclude the item? Or do we need to act on that?
Yes, we would need a separate motion to conclude the item. Actually,
Or do you want?
if there is a lack of a motion, the item will be concluded.
Okay, so then then this will be the one motion, and in so doing, if this passes, we will conclude this item and create a new file for the city attorney response and further explication on this issue, and we will continue to keep the parties advised, although the Arts Commission will no longer be the respondent. Fair enough? Okay, so that's where we're going with it. Is there public comment from anyone who has not yet spoken, either as a party or a supporting person? Mr. Piccarello.
Thank you. Good afternoon, Thomas Piccarello. Wow. This is an order of determination that was rendered November 7th, 2012, 14 months ago. This committee doesn't have the jurisdiction to relitigate the claim. Speaking of the order of determination, the chair of this committee actually found that there wasn't a violation of the Sunshine Ordinance. So perhaps the credibility of the chairman is lacking. But, I don't understand how this matter is in front of the Education Committee. It should be in front of the Compliance Committee to ascertain whether or not the Arts Commission has violated or has complied with the order of determination of 14 months ago. To suggest somehow that a committee member will now draft a request to the city attorney is nonsensical. There's already been a finding that the Arts Commission has violated the Sunshine Ordinance. Withholding documents for 14 months is not good acting. I think it's improper activity by a city agency. So my suggestion is you kick this back to the full task force for a willful finding of the order of determination 14 months ago. Thank you.
So there was a period, speaking of,
One moment.
there was a period where we went with that?
Until we change the bylaws.
Sorry, clarification question.
Okay. Is there any further public comment from anyone who hasn't spoken? Seeing none. Are we clear on the motion? Complainant respondent clear on the motion, what it does, what it doesn't do? Yes? Everyone? Okay. All right. Why don't we do a quick roll call on that?
On that motion,
Yeah, which way are we going?
Hold on. It's a motion to authorize sending a letter to the city attorney to clarify 67.21I, et cetera, and in so doing, setting up a new file on that and concluding this matter.
Okay. Go ahead, Victor, sorry.
on that motion, Member David. Aye. David, aye. Member Fisher.
Aye.
Fisher, aye. Chair Pelpel.
Aye.
Pelpel, aye. The motion passes.
Okay, so that's passed. We have concluded.
There being no other motions, this item shall be concluded.
Right.
For lack of a motion.
So 12013 is now concluded, and we're opening a new file on city attorney. Thank you, various people, for being here. And we'll open a new file on city attorney. City attorney letter. We'll come up with a better title for it.
Yes.
Okay. And you're going to work on the letter and get it to me?
I have a draft.
Okay.
I already
Excellent.
have a draft, which I'm happy to share.
Thank you, and we'll try to get that out. I don't know if we'll get that back in time for next month. We'll see. All right, anyway, it's in the works. Okay, so that was item 2. Anything further? Seeing none, let's call item 3, please.
Item number 3, file number 13024, hearing on the status of the order of determination of Miko Rigel against the Planning Department for allegedly failing to provide requested records associated with the proposed development of 480 Potrero Avenue.
Okay. One moment. This is in our packet starting at page 95. We have an order of determination, and I don't know. Yes, we did get something back from Micah. I'm sorry, I didn't notice this. Oh, this is new because I hadn't seen it.
This thing here.
Page 111, 112, there's a letter from Micah dated last Wednesday. Okay, so we'll take a quick look at that. We had already found a violation, and we've had, this was sent here. This has been a couple of different places. What we're trying to do here on this item 3 is to determine if planning has done anything further on the question of email, and whether there was anything further on paper records or other electronic records, just to address the underlying request. If there has, we'd like to hear about it. If there hasn't been, then we will see about whether to refer this back to the full task force. So that's my brief intro, and while we're taking a look at this, why don't we hear from Micah, the complainant. Thanks.
Good afternoon.
Hi, Micah.
Hi.
The status of the complaint has not changed. Respondents have made no effort to cure and correct the violation. They have not contacted me at all. They are in violation of the California Public Records Act, City and County San Francisco Sunshine Ordinance, your all's order of determination issued on October 2nd, as well as every other directive that every other committee has issued for them to comply and to quickly comply. Everything else is stated in my letter as far as what at this point I believe the department to be in violation of section 6721E. The custodian of records has refused to comply, failed to comply, and incompletely complied with this records request. Section 6725, in spite of the previous order of determination, there has not been an immediacy of response. Section 6726, withholding has been at a maximum. Section 6727, there is no justification for the continued withholding of these public records. And Section 6734, their failure to comply has been willful, and therefore the matter will be referred to the Ethics Commission for investigation of official misconduct. And last, I'm not sure about this because I don't quite understand, but on your all's website is the ethics, sunshine, and how the two are supposed to fuse. That packet, it says that under Section 7 that the ethics policy for sunshine complaints authorizes fines between $500 and $5,000 for each willful violation. And I'm sure it's some provision that you all have never issued, but if it's an option, I think you all should. And then maybe the meetings could get videotaped quicker. Or there's a way to fund everything. But at this point, as far as what's happened since last time, since the full task force meeting, I've received nothing new. Planning failed to show up at the last EOTC hearing, which was December, right? Yeah. And here we are, January 13th. And the complaint was originally filed March 31st. I think the request was first made March 14th. Thank you.
Yes.
Wasn't there a compliance and amendment? Didn't this case?
Yes,
it's a
hearing.
Yeah, it went to compliance and amendment. We were at that.
It was there, and that's why it got sent here.
And yeah, I've been to the full task force twice, to amendments and compliance once. This is now the second EOTC hearing, so this is the fifth hearing. And so as far much as I know there's a backlog of complaints, and I had to wait through that backlog for a really long time.
Okay.
I'm taking up other people's space by still dealing with this issue. And so if you all have any ability to, for penalties or declaration of saying that they are, it is definitive that they're in violation, it would be appreciated.
Okay, we're on it. And I think that the section that you were referring to was a draft policy or procedures that did not get enacted in that way. But be that as it may, we get it. Is there any other speaker in support of the complainant? Seeing none, let's go to the respondent. Jonas?
Good afternoon, Commissioners. Jonas Iona for the Planning Department. This specific case is caught a little bit in a transitional period. Let me introduce myself. As of November 12th of 2013, I've been appointed as the Director of Commission Affairs, and as part of those duties, I am now the custodian of records for the Planning Department. I'd like to acknowledge the fact that I personally make sunshine ordinances, the sunshine ordinance and responding to those a top priority for my office and the department. So I want to make that absolutely clear. In response to this particular request, the Planning Department has provided all of its records. It's actually gone above and beyond by going to the Department of Technology to request deleted emails that are non-substantive to the case to be provided in response to this sunshine request. There has been no communication with the requester because we have nothing new to provide them. And unfortunately, I know that that's not a satisfying response to the requester, but I'm not aware of any document, be it electronic, hard copy, or otherwise, that has been withheld from that requester.
Okay, we may have some further questions, so hang out. Are there any speakers in support of the respondent? Seeing none. Matters with the task force for discussion. Member David.
Mr. Ringel, please come on
Here.
up. Can you please refresh my memory? So I also, if my memory serves me correctly, there was also something to do with the timing that you got records, right? That like somehow you got records like a day after you needed them to file a. Can you refer?
I would be happy to.
Please,
sure.
yeah, go ahead.
Let's see. After the Amendments and Compliance Committee, they were told to run the search on the Exchange servers, and the question was, why haven't you run the search on the Exchange servers? So they were told to immediately comply. I was then given a CD at the full task force hearing, meeting number 2 for the full task force, and that came the day after it was even possible to file with the Board of Appeals the rehearing request. So that is correct. They didn't even run the search until the hearing on the matter, and then they did not give me the information until it was impossible to do anything about it administratively, A. B, that hearing that we put up on the screen at that meeting, we showed only 7 emails for Ben Fu. Now, unless they're willing to say that only 7 emails, Ben Fu only ever, and I have more than several dozen. And so Mr. Ionin is mistaken, and you asked me specifically, what did I learn about from that CD? And from that CD, I wrote that I learned, 1, that the search was not done until after it was impossible for me to do much administratively with the information. And there was very valuable information on that email, in those emails, and for him to say nothing substantive, we're talking about possibly like cover-ups of like stuff that people knowingly lied about, if I could say fraud or potentially. So when he says non-substantive, I respectfully disagree with non-substantive issues in them.
Mr.
B,
Ringel, can I
he
just-
did it for a limited search.
Okay, I have a quick question.
Sure.
I apologize for interrupting you. Assuming, let's just make the assumption you had unlimited resources, what steps would you be able to take next? Right, like if you missed that date. Let's assume you missed that date because you were not given information in a substantive, in a timely manner, right? To appeal.
I was, right.
Right. Okay. So what would be the next step for you in order to if you wanted to appeal what was happening? Is it over? Is it basically like, or would there be something that you would be able to do?
Is that Mr. Caldera in the back row?
I don't.
Because if so, he could tell you that there's no way to request a rehearing with the Board of Supervisors. That's over. There is no way to request a rehearing with the Board of Appeals after those 10 days. That's over. And so the information is still needed because I need it for the pending case in SF Superior Court.
Okay.
And can I finish just quickly?
Yeah,
what you were
absolutely.
saying
I just
before?
want-
There is nothing administrative unless you could go, and I asked actually at the last hearing if a letter could be written to the Board of Appeals or to the Board of Supervisors, and I was told that you all do not have the power to do that. So
Is he still missing information?
back to number 2, was that the request was done for 480 Potrero Avenue in quotations, limiting the results to only 480 Potrero Avenue. Most people don't spell out the word avenue. So if anybody wrote about 480 Potrero or Potrero Ave, it was not returned. Commissioner Pilpel asked for, through Victor, what the proper search terms would have been, and the proper search terms were outlined in my initial request, and I had a laundry list of things. I asked for several consultant agencies. If you read the letter from your all's lawyer who wrote up the background on the case. And then the last thing was, she said that the information I requested was only available from August 1st, 2012 forward. And that was all that she gave me, yet when they ran the search, there was the log of every file that was searched. And so it was able to search for, through Ben Fu, back to 2003, and for Don Lewis through, I think, 2008. And so inasmuch that she said it's only available from 2012, that is not correct. The information is there on the servers. And so I actually listed a whole bunch of emails. Why were there only 8 questions? Why were there only 8 emails for Ben Fu? Why did the planning department show up for the last DOTC hearing? Is this willful noncompliance? And yeah, it's so I respectfully disagree with pretty much everything Mr. Ionin said, that they don't have anything else.
Okay. Let me try to get hold of this.
I have a question, too.
Okay, everyone's in the queue. I got it. Let's try to keep this focused on the request. We've got another item after this where we're going to talk about the planning department generally, but on this particular request, I'm going to repeat what I asked before. So, Micah, let me speak to Jonas for a moment. So, Jonas, you and I spoke about this. I spoke to Lulu. I spoke to Tom DeSanto. So I think you're pretty familiar with the circumstances by this point, yeah?
I believe I am, yes.
Okay. So what was originally requested, and, you know, I could find the date in here, but it doesn't matter. The original request was for all documents, in addition to any emails and other electronic forms of data held in custody by the planning department, re 480 Petro / 2011.0430, whatever suffix. So what I've asked before is, did the planning department search for and provide all paper documents related to that address or that case number? As far as you know, the answer is?
The planning department provided everything written and electronic.
Hold on, let's do one at a time. Paper records, yes?
Within our possession, yes.
Okay. Electronic records, i.e. Excel spreadsheets, PDFs, anything like that that's stored on a local or shared drive relative to that address or a case number? Yeah?
Within the planning department's possession, yes.
Okay. And then the third was email. So I think where we're at now is just this question of email and the search term and the date range. So the last conversation that I had with Tom DeSanto was to ask if the department could either request the search that DT did with different terms and a different date, and he did not know what the cost would be of that, so I asked if he could at least determine what that cost would be and either share that cost with us, the amount, what it is, or make a determination at the department level based on that cost whether to absorb that and do it or not. Do you know the result of that line of inquiry?
I don't know what the cost would be to the department.
Okay.
Outside of the expending additional resources on that, because it's not as though DT provides us with just certain emails as a result of that search. It's a laundry list of emails that then our IT staff has to go through and sift through to respond to the requester's request. More importantly, this is the first time we've ever done that request to DT. Okay. It's a new precedence that I'm cautioning to even continue going down. And quite honestly, I'm not sure what, if anything, it would provide new for the requester. Like I said, we've provided every substantive piece of material, be it electronic or written, that is in our possession. I believe quite strongly that we've complied with the Sunshine Ordinance as it is written, and I respectfully request that this case be closed.
Okay. I just want to be clear, and you may want to take a note on this. On the bottom of page 114 of our packet, the request from Micah was to rerun the search with 480 plus Potrero, not Ave or Avenue, or 2011.0430 with an asterisk, so as to create a wild card that it would find anything with 480 and Potrero or that case number. Hold on one moment. And to rerun that search going back to, since Micah didn't make a specific date request, I'll suggest January 1 of 2011, since it was a 2011 case, and anything before 2011 would seem to me like it wasn't relevant to that case at that address. It may be relevant to that address, but if it's prior to 2011, then it wouldn't be relevant to that case at that address. So that seems to me to be a reasonable refinement of the request. That's what I believe Micah was asking for some time now, and clarified at least to in his email of December 12th, which I believe, hopefully you have seen. And so if the department were to do that and provide that information prior to the full task force meeting, I think you would be in a better position. If the department doesn't, I think you won't be in a great position, and so we will discuss in a moment whether to send this matter back to the full task force. There was, I would suggest great unhappiness at this committee last month that planning was not here, because we specifically scheduled it at this committee with Lulu's assurance that she would be here at a minimum, and that she would get either you or Tom or somebody else from planning, and that didn't happen. And so I'm just reflecting on that situation, if you want to comment back on that.
Well, just on the matter of the request, I'd like to get back to the actual request itself. My understanding is that the request for a second request to the Department of Technology to do yet another search on this matter on emails that have been deleted from the Planning Department's possession is based purely on the fact that the first request developed some emails that were deleted. That's going to be the case for any item that comes to the Planning Commission or the Planning Department.
Understood.
Planners are not going to retain every single correspondence that is a back and forth between a planner, a requester, an interested party. If it is a substantive matter, in other words, they are providing comment to the project, if they are requesting specific information on the project and the planner responds, that should be part of the public record. And to the best of our ability, we do retain those emails and correspondences as part of the public record, as if someone were to submit something in writing in hard copy. We would add that to the correspondence folder in our docket. Because that is the reason of this second request, I'm very reluctant to make that request to the Department of Technology, because there will be probably more emails that come out of that search, and this same request can be made yet again. When does it stop is what I'm asking for. And also, if there is a specific document that the requester believes has been withheld, that would make the search more pertinent and more specific and something we can target, as opposed to just anything under the sun related to 480 Potrero. It makes it extremely difficult for us to respond to something like that.
Okay. You will. I just want to be clear, the original request was for that address and that case number. The burden really isn't on the requester to identify a specific document. He was asking for everything you've got on that case and that address, and so he's been pretty patient, and we've made an order, we've held several hearings on it. Where this ends is if you would rerun the request as I've pretty much outlined, and if whatever that yields, if that gets to Micah, as far as I'm concerned, that's the end of the instant request. What he does with it is up to him. Where it goes thereafter is beyond our jurisdiction, but at least getting him that stuff is what we're trying to do and what we found. So that's what's going on here. If, as I said, if that happens, that's to the good. If that doesn't happen, I think there's a strong likelihood that the full task force is going to send this to ethics for an investigation and a hearing, and you and Tom and Lulu are going to get dragged into that, and I would say there's an even chance that Lulu's going to get dragged through something and get some nasty ding letter. If you want to avoid that possibility even, I would encourage you to just do this thing, as unpleasant and whatever as you may find it. Sometimes there's stuff that we just have to do.
What assurance do we have that that won't happen anyway if we run this?
My assurance that there is...
We have none.
Right.
I can't prove,
as I say,
prove that something that doesn't exist doesn't exist. It's simply impossible for you to prove.
That's true. And
hear that a lot.
That's true. But we do know that there were emails that were...
And if I may just finish my thought.
Go ahead.
The Planning Department did comply with the Sunshine Ordinance request. We provided everything within our possession. Department of Technology is a different department that is not under our purview, per se, or direction. So it is under their possession, is not under our possession. It is under the city family umbrella, certainly.
So are you saying that the email search that DT did was not of active current email, but was only of deleted email?
That's correct. We can do our own search of active emails within our database.
And did you do a search of emails in your active database for these planners and this address and this case number for the date range that I indicated? Did that happen?
Well, maybe not the new date range that you've indicated, but certainly the date range that this case has been active. So in other words, from the date that basically the applications come into the door and we've begun receiving correspondences in the application, all of that subject matter has been provided to you and the requester.
Micah, can you clarify that for a second? The original emails that you got versus the stuff that was on the CD?
This is the original runaround game, and this is why it's a problem when the people who the Sunshine complaint was issued against aren't at the hearing. I said that at the very first hearing. Why isn't Don Lewis and Ben Food here? They
I'm
could tell
just
you.
asking.
They're the ones who said that they only had to issue.
Okay, hold
Don
on.
Lewis says they only have to issue forward.
Okay,
but they didn't
hold
have
on.
to issue anything
Please,
backwards.
Please. The emails that you originally got from planning versus what came on the CD through DT,
They never ran a search.
you're not clear that they ran a search of their of the original emails at planning?
They didn't. They printed out selected emails almost entirely from me to them, the emails I essentially already had, A. B, they're now trying to tell you that they're not in possession of emails where they are in their sent folder. You have to search the entire mailbox. Nobody
Okay.
deletes what's in their sent folder. And then C, he's trying to tell you that the search from the DT server that were on in purview of the DT servers, those are still owned by the planning department. The planning department pays
Okay.
DT a subsidy for them.
I understand. Okay,
And
I
then
got
that
it.
part of it, those are archives. They're not deleted. And so
Got
that
it.
part's not correct either.
Okay, thank you. Jonas, do you want to comment further on that briefly or not?
Only that when we do a search under the Sunshine Ordinance tab, as a result of a Sunshine Ordinance, we don't look at just received emails. We look at the comprehensive database of emails that is active within the planner's email database.
That may be
In their inbox, so the sent folders, sent items, and whatnot.
That may be the general scheme. Do you know for a certainty that that occurred in this case?
I can't speak to what each individual planner has done,
Got it.
and I don't think anyone can.
Well, the individual planner could, but okay. That's it for the moment. Let's.
No, wait a minute.
All right.
Talk to him. I
Okay.
can talk to Micah too now.
There was an expansion. There was an expansion of the Sunshine complaint, and I asked for everything held within the custody of the email of the planning department. Whereas Mr. Ionin has never run a search on his emails or his, and I've had several communications with him. Some of them that have to do with the Sunshine Ordinance, asking that he forwarded the planning commission the information about this case, and that the planning commission not tried this case before you all could decide this case. And so much as Mr. Ionin has not done that search, then there's a problem too, because there's a lot of people at the planning department. We could focus on just Ben Fu and Don Lewis, because that's who it was originally made to. But to Lulu Huang, who was in charge of the entire department, and at the time in charge of Sunshine for everybody there, I said everything held within the department, everything held within the custody. I think I used her all's terminology too. And so as much as Mr. Ionin has never, Sarah B. Jones, who was here last time, before that it was Nanny Terrell. And as much as none of them have either, that is also part of it, I suppose. And it is substantive information. I vehemently want to defend that, and I can show you how it's substantive and how no one looking at it would say that is not important and not substantive.
Okay.
So, Micah,
Thank you.
Member Fisher.
I have a bunch of questions for you, and I apologize if some of you want to leap across that podium and, grab me and shake me and say, I've answered this 5 times already, so bear
Go
with
ahead and ask.
I'd be happy.
You had your time. This is my time. I vividly remember this case because I was filling in for Chair Grant that day. 2 people were out of town. Somebody was sick. We only had 6, and you got all 6 votes. That doesn't happen all that much. So you got, you have to get 6. You got all 6. I mean, this was a very serious case. We took this very seriously, and I believe this is my 5th time seeing you. As I was at the compliance and amendment. So. And bear with me if I'm asking questions you've already answered. What I'm trying to get to here is, how the heck we can make you whole on this, because I've had some flirtations with planning, too. Some have been successful. Most have been. My question is, do you think, and I'm using my words very carefully. I'm looking at my screen as I typed them. Do you think that there's some missing data? Do you know that there's missing data? Wait, I have the third one.
Okay.
And the thing that kind of gets me, having been a database administrator back in my earlier life,
That's good.
they only did a search on 480 Potrero Avenue. I mean, if I were doing this search, I'd have done 480, I'd have done Potrero, I'd have done Potrero and blah, blah. I'd have done the names of, the project. And, I mean, I have to ask who's ever here from, I can't remember his last name, Mr. Jonah, who was here. I'm inclined to say, let's give this another search for this guy, Micah, who I know for every minute you spend here in front of me and my colleagues, you're spending hours out there in doing this research. I mean, I got to tell you, dude, I don't know what your career is now, but this would be a path for you to go into this.
Thanks.
Searching things, because you've done a really
I'm a pretty good
complete
researcher.
job.
I know there's information, and I have information. I'm in possession of information. But in as much as I know it exists from them, I want it from them. I don't want it from my email account that's been forwarded to me. I want it from their email account that was sent from them, A. That's important. B, there's an entire gray area of what I'm trying to fill in that, whereas if I had any communications or could see anything how a case was to progress, it would be really helpful to find. How to make me whole now. If they read the original complaint written by your city attorney that is very clear on what I was asking for, I've never been given a single Word document. I've never been given a single spreadsheet. So as much as spreadsheets and Word documents exist on their hard drives currently, then I should be getting those. All of the communications were defective that I was first getting because they were PDFs. They didn't have attachments attached to them. The version that I got, that CD from Lulu Huang, was much better, only it was such a limited search term that it eliminated a whole bunch of information. And for Ben Fu, to the fact that it only got 7 emails, and I believe there's even likely a lot more than 7, and I believe that they're withholding that someone pulled them. And then I also wanted to let you know how the Exchange server works, is that both of those accounts are frozen right now, or a copy of the accounts have been frozen on the servers, called litigation hold. And so a real simple way to make this really easy would be just copy the whole litigation hold. I'm easy to do the search terms for 480 Potrero Avenue, for the consulting companies, for the other. I'll take their entire email boxes, everything from Ben Fu from 2003 to whatever. It exists on the server. It can be recorded real simply. These searches do take time for the computer to run. For instance, even for 480 Potrero Avenue, for both planners, it took overnight, basically. But it certainly can be done for the search terms that I asked for, and that it was really limiting by putting 480 Potrero Avenue in quotes to begin with. It was ridiculous. But the information I was given was so enlightening that it was, all of a sudden I have proof of things that I brought up to the Board of Supervisors, that I brought up to the Board of Appeals, and now I have actually the information from the planners saying it to each other. And so it would have made a difference at the hearing, at all the hearings, including the Planning Commission hearing, which Jonas is the administrator for. It would make me whole if they would run the search, or it would make me whole by having a declaration saying the Planning Department has not complied with these sections of the Sunshine Ordinance, because I can then use that in round 2, which is out of the administrative hold, because that is where they placed it to. And I just want to say, like, not only have I invested a lot in this, but also my entire neighborhood group, the Mariposa Utah Neighborhood Association, has paid hundreds of dollars for these appeals. From the Board of Appeals, they're not refundable. My neighbors on either side of me spent $1,500 to have a model made for the Board of Appeals hearing. I mean, everybody in the neighborhood has invested a lot in this, and even the fact that I'll be getting this information, if at best, next week, because, like I said, it does take time for these searches. They've already cost everything. There's no way to reset what they've already done, and this was deliberate. And I did a little. I tried to do research on all of you. And Member David, you're a parent. One of the things about this is that they're going to be drilling into asbestos within a quarter mile of the school. And as a parent, you have protections that when you send your child to school, asbestos will not be in the air in a project within a quarter mile. And so the planning department decided this wasn't important enough. And so even though the school is within a quarter mile, they decided it's all right that they can drill within asbestos without notifying the school and therefore the parents. Now you can say a quarter mile is a pretty good distance away, but there's a school bus stop for the low-income families that live directly across the street from this project. And every morning, there are going to be kids standing there, and there's going to be asbestos being drilled into right across the street, and they've never been told about it. And so, as a parent, I want to appeal to you that at this point, for me to be getting this information, it's really late, and how it affects not just me and not just my neighborhood, but a community as a whole. So, thank you.
I got a turn? You will in 1 second. Member Fisher, are you good?
Yeah, I'm good.
Okay. Member David?
Well, he's just walked away.
Yes.
Jonas, please. So, I say this very respectfully. I really do. The planning department on this case is really unsympathetic. From my point of view, has a very unsympathetic case. The planning department provided Micah with information the day after was the last day for him to file an appeal. That just looks, through the prism, whether it was purposeful or not, looks terrible. It just looks bad. I have to say that I agree with Member Pilpel that I feel that it is in the planning department's best interest on this case to go above and beyond to prove that you guys are trying to be as cooperative with Mr. Ringel as possible, because right now it does not look good from my point of view, and perhaps from my colleagues' point of view up here also, that this looks really suspicious. And so,
Not saying that it is, but it looks.
Its appearance of being very suspicious. And so, if the planning department truly is trying to provide Mr. Ringel with all public information that he's requesting, and you're concerned that, oh, this is setting a precedent, I would encourage you to not worry about that at this moment. I would more be concerned about that the Sunshine Ordinance Task Force is probably going to send you guys to ethics and fine you in willful contempt if we do not feel that you are being cooperative. This does not look good from my point of view. So I hope that you will take what Chair Pilpel said and what I'm saying very seriously and work with Mr. Ringel in the most open way possible to get him every crumb of information that he's looking for at this moment. Because otherwise, I think that it is really, I'm disturbed by this, and I don't get disturbed by a lot of cases up here. This one really bothers me and really sits and eats at me. So you guys can certainly choose to do as you want to do and what you see fit, but I just want to be very clear on how this looks to me.
Make a motion or something?
Well, we're going to make a motion in a moment. I think we're headed there. Why don't we do clarification rebuttal, and then we'll make a motion, take public comment, and see if there's a vote. So, Jonas, before you go away. I think you've got the respondent's clarification rebuttal, so you have up to 3 minutes to wrap up on this.
Look, this is the first time I'm coming before you in this capacity. Okay, I want to get off on the right foot. I'm also very cautious and wary of establishing precedents for future cases because clearly I don't want to go through DT ever again. Okay? I think in the following case after this, I'll explain why we won't need to do that. And I'm certainly not convinced that going to DT a second time is going to prevent us from going to the Ethics Commission, but if that's where it takes us, so be it. Because I truly believe the Planning Commission has complied with the Sunshine Ordinance in this case. I will request from DT to run a second query. However, I would like from this body a specific list of search items to be requested. And as Mr. Ringel has explained to you, it's not an easy process. It's time-consuming, it's resource-consuming for both DT and the Planning Department, which is why I'm reluctant. Okay? And as far as I'm concerned, just to be clear, again, I don't see this preventing us from going to the Ethics Commission. I see this case going to the Ethics Commission. If it has any kind of an opportunity to prevent that, great. I'm actually doing this because I want to get off on the right foot with you because I expect to be in front of this body again in the future for other cases, unfortunately. It's just the way it goes. But I would like to limit the number of searches. And we can't search 480 Potrero, 480 Potrero Ave, 480, the number 4, the number 8, the number 0, with the letter P. I mean, let's be real. I don't know, what's the appropriate number of searches? 5, 6, I don't know, but it has to be limited. Please.
We'll get that. That's cool. We appreciate that. Micah, it's your chance to...
3 minutes.
Yep, clarification rebuttal.
So, Mr. Ionin, here's the last 3 emails that I made available to the task force. If you read these and you read the very first email, that would be everything. You have search terms. It's 480 plus Potrero 2011.0430 exclamation asterisk. It's pretty simple. Nobody's ever complied, so if you will just comply with that. As far as the boxes, I would like it for anyone who's been connected to the case, because this was originally back in March. I was supposed to be able to see the communications and then follow the communications and then see this is connected to, okay, so then well, let's see what they did. What, you know, there was supposed to be a method here to this. And so in as much as that never got done, that would have been the next logical step in research is you see how it branches out. And so whereas the planners would know everyone who has, because like I said, even though they're not supposed to segment, they segregate their cases as a policy at the planning department. So there's the E file, the X file, the exclamation point file. So when we start with those supervisors and their superiors, the planning commission included, and I think that would pretty much be everyone, whoever was in charge of the case file, communications ed with their superiors, and then everything from the commission, I think that would be everything. And the planning department's probably 300 people work there. That maybe be 20 people or something. And as much as it takes a long time, that's fine. As much as it's a precedent, they set up so that their email servers were on Exchange 360, which is like a cloud email service. So they set it up that way. The administration point is just the same. And as long as it takes typing in open search, enter search term, click, and then the server runs overnight and it shows up in the morning, the results. It's not time consuming. I would go do it if I had access to the servers. And then there's a provision in the Sunshine Ordinance that says clearly anything that's on tape, anything that's on, and it doesn't limit to 5 searches, and it doesn't limit to certain periods. And actually, like I said, I know there's a whole lot more because I can see everything that the previous Exchange server search, when they finally ran it, searched through. So it's not as hard as they're saying, it's just foot dragging. And every time someone comes and says, we've given him everything that there is, there's nothing else. And they say that as if they believe it themselves. And then obviously there's more. And so I would appreciate the more. Thank you.
Okay, there's a follow-up
I have a
question.
question. Micah, I have a question. Two questions for you. One, am I to understand you correctly that there's basically two search words you're looking for? Because I'm not a technology person. I just want to make sure that you said 480 Potrero, and then some number that you just...
480 Potrero, and then the case file
And the case
number
file.
should yield everything. I would be happy if they just ran Potrero for everything. That should also show it up because no one ever really, even if I got stuff that had to do incidentally to Potrero or something else had to do with Potrero, it's the Potrero project. So anything that has to do with Potrero for those planners should yield it.
So but it sounds like, I just want to be clear, it sounds like you're talking about very specifically two searches, 480 plus Potrero, and then 2011.0430 star.
Should yield, yes. Yes, those would be the two.
I'm going to ask you a follow-up question. If you felt like you received every document from those two searches, would you then not be inclined to pursue this being pushed to ethics?
I have the paperwork already filled out for ethics.
Okay.
Because I just learned that after 45 days of noncompliance, it is an ethics issue. And so I don't see the problem of this going to ethics if there's been noncompliance. But in as much as I said at the last hearing, I've been damaged by this.
No, I'm not.
They've cheated, in my opinion. They had the information that was needed, and they weren't sharing it deliberately so that they could win the hearings as if it was a game. And I think this needs to go to ethics because, in as much as I don't understand why I'm at an education and outreach and training hearing, because I don't think it's an education, outreach, and training issue. I think it's a very particular issue, particular to this case, and I think it's deliberate in nature. It has nothing to do with policy, and I think it would be beneficial for, although I don't know where it exactly takes, would go from that, but this is willful, and so I suppose it doesn't need to go to ethics if I had some sort of order that says it was willful, but if you read everything that was put in the order of determination now, it says they were guilty of some things but not of others and not of the willful complaints. And at this point, I have to go to willful. This is my 5th hearing, and I still haven't gotten the information I've gotten. And every time I get information, and it's always, so at some point it's going, I think.
Yeah, thank you. I appreciate your candor.
Okay, and thank you. And to clarify on that last point, I'm not sure that was an entirely fair question because I think it's actually a matter for the task force to determine not what, but...
Sure, but I also think that as the complainant, he might come back to us and ask us one way or another, and so that was what I was getting at. It is you're absolutely correct. It is
and ultimately, I think this is a question of good faith on all parts.
Agreed.
So,
I agree.
and I think hopefully in the room now, we're trying to get to a better place. I just wanted to clarify to Micah, is it just of you talked about 20 planners. Is it the 2 planners? Is it any planner that touched it? Is it the entire department? I want to get real clear because if we're going to ask planning to
That's a really good question, and I'm not exactly sure how segregated the case files are, but I could tell you that the shadow case file is Sanchez, but not Scott Sanchez. Diego Sanchez or
Diego Sanchez.
Diego Sanchez. Okay, because there's 3 Sanchez's, I just learned. So that would be a good one. And then he shares an administrator with Ben Fu, I believe. And so whoever is in possession of a case file, because they're in possession of, they would be the custodian, right? As well as their supervisors. And then I guess Sarah B. Jones would be the only one who's the ultimate supervisor for it's probably literally 10 planners maybe, but there's an E case file, K case file, I think traffic was Wade Whitgriff. I mean, I can tell you the names if you wanted to know specifically.
No, I don't.
But I think it's more like 10. I said 20 just to overly.
Is it, and is the January 1 of 11 a fair start date?
Give me 1 second to think about this. The application for PPA came in April 11. So yeah, January 11 would be
Okay.
totally perfect.
And your original request was March 31, 2013, so I have no problem having the end date be 3/31/13. Anything since would be the subject of a separate request that you'd have to do. I'm just trying to limit it to the request that you made.
Well, in as much as I've never gotten that, and the records which the city is obligated, which are needed, go to the point of project approval, which would have been, I'm only entitled to the records, I guess I should say that. The reason why these records are now needed is because, see, I have a letter from the office of the city attorney here saying they want
That's not our issue.
$2,000 for this information, which I can't get from you guys, but I've been trying for quite a long time.
Okay, I don't want to talk about the court case and what you're
Right.
doing on that. Not our thing.
It would be
So-
appreciated if they're going to run the search, then the search would go until August 8th.
Okay. But at a minimum,
August
if we get you the stuff from January 1 of
November.
11 to March 31 of 13, that would satisfy your request, which was the subject of this case. They can choose to do more, but at a minimum, that would satisfy this. You could also file a separate request for anything since March 31.
Oh, wow, okay. I didn't realize that would be segregated like that. I just assumed because I made several requests interim for files and actually went to go see the files, then every time they said I had everything, it was the same story. In as much as they didn't, I figured,
Okay.
well, this case was ongoing,
Just so
it would be
everyone
cumulative.
just so everyone is clear, when you make a request for public records, it covers records that exist at the time the request is made. Records that become available or are created subsequent to that date aren't covered in a request. Requests aren't prospective.
Can I make a verbal request now then, since I have the
You
custodian
have
of
and you
records?
do, and we can incorporate that in our correspondence,
Thank you.
but that's really the subject of a separate thing. So I got it.
Okay.
So let me go to Jonas so that we can be as clear as possible orally, and if we need to follow up with the letter, we'll do so. Sounds to me like January 1 of 11 to March 31 of 13 with those search terms makes sense. Do you know if searches are done on an individual mailbox or if it's the entire department, how that works? I mean,
I'll have to learn what that process is.
Okay, so it sounds to me like at a minimum, it would be Ben Fu, Don Lewis, and Diego Sanchez, and if necessary, or if it's not that complicated, anybody else who might have touched the thing. It sounds like those are the basic case planners.
For clarity,
Yeah.
we're going to request, the planning department will be requesting DT to run 2 searches at the minimum with the search terms 480 plus Potrero, 2011.0430. I'm not sure the asterisk is going to be beneficial. I think it's going to
I think
complicate.
it may. I don't.
The asterisk is not a...
I think it's a wild card term in the search, but you'll want to clarify
okay,
that
if
with them.
If that's what that's for,
Yeah.
then, okay, to me, it would confuse the search, but we will run it that way then.
Okay.
2011.0430 asterisk.
If the way they
from
run
January
it-
1st, 2011 through March 31st, 2013, at the minimum for planners Ben Fu, Don Lewis, and Diego Sanchez.
Right.
Yes?
Hold on. Yes, and I guess because of the nature of this thing, we should probably do a letter to you that confirms that, saying that that's what we're asking you to do.
That would be wonderful, because I'd like to make clear that this is the last request the planning department's going to be making on this particular item. I mean, really, this is going to be the last request we make.
On this matter, if there's a subsequent request from Micah as a separate request, then you'll have to deal with that. But from the task force, this is what we're asking you to do.
Okay, but
Okay.
just to be clear,
Yeah.
after this request, we're closing this.
I get it. Okay, so I guess that's where we're going with it. Hold on a second. Okay, I think we were good with we're good with the clarification and rebuttal. I think now we need a motion so as to keep this. I'm not sure that we need to have this back at this committee. I think what we need to do is send this to the full task force so that the task force has an option to refer if it's not satisfied, or to not refer if it is satisfied, or to send it back here, or to do whatever. But I'd like to get it out of this committee.
It's the most options.
Right. So I think a motion to refer the matter back to the full task force with and notify all the various people, and I'll give you a list of people for that action, and to authorize a letter from this committee to memorialize the discussion that we just had about the further search that we're requesting. Does that?
Yeah.
Okay.
You want me to make the motion?
Sure.
So help me out here, Chair Pilpel, if I miss anything, but I'd like to make a motion that this gets referred back. I'll be visiting with you again, Mr. Ringel, to the full task force. And what else am I adding?
Authorize a letter.
And we're going to authorize the letter to,
Detailing the search terms.
thank you, detailing the search terms of what I recall so far was 480 plus Potrero, and then the case number 2011.0430 with a wild card asterisk.
Right. Yeah, hold on, we'll get to that. Detailing search terms, dates,
You want to
kilometers,
go with the dates, January 1st, 2011 to,
right? We got all that.
okay.
And I'll include that confirming paper and electronic have already been, and if not, they should.
Is that part of the motion, though?
To ask planning to
Okay.
confirm that they have, or whatever, and that they should attempt to do all that prior to the full task force meeting, et cetera, et cetera.
It's important that Victor got all this.
Victor will get enough of it, we'll clean it up, and I'm authorized to draft and send this letter.
All right, do we have enough for a motion that you can repeat back? Or do you need me to
The
summarize a
motion
little more?
is to refer this item back to the Sunshine Ordinance Task Force, I believe for the February 5th meeting, is that correct? In addition, we are going to request that the Planning Department perform another search with the search terms 480 plus Potrero, 211.0430. And we are authorizing the chair of this committee to issue a letter to detail the search terms and so forth.
And so forth, yes.
I need a second.
Member
Second.
David? Okay, so we have a motion and a second. Let's just clarify, Jonas, are you clear enough on it? Okay.
I'm not clear on the so forth part and et cetera,
But you're paying attention, we like
Details of
that.
the search terms will be issued in the letter.
Yeah. And Micah, did you have names to share with us? Because we got Ben Fu, Don Lewis, and Diego Sanchez.
Sure. Julian Benalis, Sarah B. Jones, Victoria Wise.
Hold
A
on.
little bit slower, please.
I'm sorry.
I'll tell you what.
Can I email them?
Yeah, can you email that list to Victor, like, tonight?
Perfect.
Okay, that would be cool.
Thank you.
And I'll incorporate that in the letter, and that'll be our request, and we'll also indicate that if planning wants to provide records subsequent to that date, they're free to do so, but our request is for that date range, so you get the stuff that you originally asked for.
Thank
Okay?
you all very much.
That's the motion. Is there any, thank you. Is there any public comment from anyone who's not a party? Mr. Piccarello?
Thomas Piccarello. It's sort of hard to speak on a motion that involves language of and so forth, but I'll try. Quite frankly, you did a better job on this agenda item than you did the first one. At least you're pushing this matter to perhaps, hopefully, a conclusion. I'd just make the recommendation, though, that you make a finding of a willful violation, and then in the event that there is compliance pursuant to your motion, the matter would then be taken off calendar. Thank you.
Thanks.
Thanks. Any further public comment? Mr. Pitts?
Yeah, this still needs to be on calendar because what happens oftentimes is it gets dropped. It comes here and then nothing happens afterwards. So it needs to be back on calendar. Kick it to the full task force because it seems like this guy is not getting the information. I mean, it seems like there's not even a desire to give him the information. The guy's statement saying like this is the only time that I'm going to IT, is very appalling. I think he's in the government, and the government should be trying to get it right instead of trying to assert some type of power as to what they will and will not do. It's just very tragic because, somewhere along the line he needs to go to court because they're dumping asbestos throughout the community and the children, and this guy, he lives in another neighborhood, so why should he care? I just hope someone along the line he can get some type of justice and some type of habitable neighborhood. It's not appropriate.
Thank you.
Thanks.
Thank you. Is there any further public comment? Seeing none, I'm reminded, looking at Rick, public comment is closed. Okay. We have the motion before us, it's made in second. Let's do a quick roll call on that.
I just confirm that the motion is clear, as there are some issues with it. The motion is to refer this item to the Sunshine Ordinance Task Force February 5th meeting. The chair is authorized to issue a letter stating the search terms that the Planning Department will use to perform an additional search. And
That we're requesting them.
That is requested by the Education and Outreach and Training Committee. On that motion, Member David. Aye. David, aye. Member Fisher.
Aye.
Fisher, aye. Chair Pelpel.
Aye.
Pelpel, aye. The motion passes.
Great. Okay, so thank you very much. You'll send us those names and anything else. Thank you. And we will send a copy of the letter to Micah and to Jonas. Okay. That was item 3. Dragging a little bit, but let's do what we can here. So item 4, let's call that.
Item number 4, Planning Department Public Records Policies and Procedures.
Is there any documentation?
There was none submitted.
Where are you going?
Thanks, Rick.
Where are you going?
Okay.
You leaving us?
Okay. Very good.
I hope you found it scintillating.
Okay, come on, we've got stuff we got to do. Thank you. All right, so Jonas, we had requested this as a separate file because we were concerned that there be adequate documentation of the policies, procedures, forms, and checklists, that sort of thing that planning uses to handle records requests generally. I had asked for that to be provided so that we could have it in the packet, and we got nothing. So can you talk to us a little bit about the existing policies, procedures, forms, checklists, anything like that, and what's on the horizon given that this function was transferred to you, and et cetera, et cetera.
So thank you for this opportunity. I'd like to get that last item behind us and sort of move forward because this will be a new era under my stewardship. The custodian of public records responsibility, as I've stated to you, has shifted from my predecessors to my plate. Although my predecessors have established an effective baseline by which the department actually operates, I do feel very strongly that there's a lot of improvement or opportunities for improvement that can be made, okay? First and foremost, our records retention policy is somewhat antiquated. It hasn't been updated in some time. And so I'm currently working on a draft for that new record retention policy. We have absorbed about 30 new hires over the last over the last calendar year. And they need to be appropriately trained, okay? And just to clarify, the planning department actually doesn't amount to 300 employees. We're at about 195 employees to date. That's right. Okay? Yep. But again, no procedures manual on Sunshine Ordinance requests has been provided to existing or new staff. And I think that is first and foremost on my to-do list. The planning department is actually conducting or is creating a introduction for these new planners. It's about a day and a half in February, and one of the items that I will be going over with them is information related to the Sunshine Ordinance, the Brown Act, and how each and every employee and planner of the department is actually a custodian of record, and that requests can be made verbally in writing, or the one document we do have is a request to review public record, which is available online. They can fill that out and submit that. But again, as I stated, the ordinance clearly states that the request can be made in any fashion. So they don't have to fill out this form. It helps staff when they do fill out this form. So we will be establishing very clear procedures, and files will be created in a new record request file to catalog all of the requests that we receive. And therein lies a little bit of the subjectivity, because a Sunshine request that can be responded to by a planner immediately in an email response, I don't think merits necessarily creating a whole file for. So it's going to be a substantive request, and I understand substantive is a subjective term, but to the best of our ability, when they are voluminous and they involve more than one person or something that can be responded to immediately, I think merits a record, because that's something that the Sunshine Ordinance does require each department to provide you, I believe, or the Ethics Commission, with a tally at the end of the year of the number of requests we receive. Well, if I'm wrong, that's fine.
You can choose to do that. You're not required to, but that's cool. And just as we heard in the previous item, the Arts Commission is choosing to do a log that helps them and helps the public. So, if you choose,
I don't want to create any more work for any other department. So,
yeah, okay.
For the planning department, we'll be doing that.
Okay.
So first and foremost will be written procedures, the new record retention policy, training and dedicated resources. We're going to be hiring a planner 3 in my office to assist me as the custodian of records to respond to Sunshine Ordinance requests. And I think the intent will be for that person to follow up with requesters, either verbally or via email, to really boil down to what that request is. A lot of people ask for voluminous requests. Let me get everything under the sun associated with this particular subject matter, when what they're really looking for may be a very specific document that maybe we can provide and generate for them much faster. Okay? So that's kind of the way it is. That's the plan moving forward.
Okay, great. So let's see. Can we get a copy of the current form for the file? Thank you. At this point, that's the only form that exists. Are there written procedures that you're currently using, or not so much?
Not for the procedures in response to Sunshine Ordinance requests. No such procedures manual exists. The only other written form that really pertains to the subject matter is the record retention policy. Understood. But it really talks about the length of time that people retain documents. That's all there is. Okay. Oh, more importantly, actually, what I've found is the biggest controversy at this forum or in front of the entire task force really involves emails. And so this is, even though they've been around for a long, long time, that's sort of the crux of a lot of the allegations that are brought up against the planning department. And so we need to do a better job of retaining substantive emails, okay, and make it easier for us to search. And so one of my more immediate directives will be for cases and building permits where we begin to receive a large amount of substantive emails, that there be a folder created in each planner's inbox so that they can save those in a folder, and when that case gets closed out, just like hard copy materials, that email folder either gets printed out or saved in electronic format so that it can be accessed in the future. Right now, moving forward, with exception to the hit or misses on emails, all of our files, almost all of our files, are actually available electronically, and they're much more easily obtainable by the general public from our website even.
Well, okay, so let me jump in for a second on this, because as you know, I too have had a long history with the department, and positive and less than positive experiences. So taking as an example my interactions with Nani Turl on the Recology Rail Hall thing with Yuba County. So there's a paper file that I've reviewed a couple of times, and she has email, some of which may be new and some of which has been sitting there a while. Not all of that email is printed out and put in the hard copy docket file. Some of it, may be just transitory and doesn't need to be retained pursuant to the record retention policy. Some of it may be substantive and should be retained. At some point, possibly in a few months, Nani may retire. And so if she retires and her email box goes away, if all of that stuff that's substantive doesn't get transferred somewhere or printed out and put in the docket file, then it sort of disappears, and that's kind of a problem. So can you kind of think of examples like that? And what's her name? Joanna, who was there for, a year and a half, 2 years, something like that, and has now left, right? So anything that she had in her email is possibly gone. She wasn't a planner, she was a public information, whatever, but transitioning those things that are electronic, if you're living in the electronic world, to paper, right, that back and forth needs to be teased out a bit, both as part of your training and part of the procedures. So that's some feedback. As we said, you don't have written procedures right now. If you develop procedures for how things are handled, and we've had back and forth over the years about this request to provide identification, and as you saw in the form that you just had up there, there's something that people need to initial that they understand the procedures. That's not actually countenanced in the Public Records Act or the Sunshine Ordinance, so you want to clarify those procedures. And if there's anything else like that you develop as part of your written procedures, we would be happy to review that and comment back, either as the committee or as individuals. We're happy to give you that feedback. I think we would like there to be good and clear procedures for the public, for staff, for everybody, so that when a request is made, or prior to a request being made, people know how it's going to be handled, and that we invest more in policies and procedures up front so as to avoid as many complaints and hearings before the task force or this committee as possible.
That is my intent.
Yes. And I'm not sure, you mentioned that you're getting a new planner to help with this. I'm not sure why that function needs to be a planner and not a clerk or some other classification in the city.
That's not the only assignment they're going to be doing.
Okay, well then maybe that explains it. And I'm sure I will see that further in the next month or so in the budget narrative before the commission. Possibly.
That's already there. It's been on the books for a year. They've been waiting for my appointment to happen in order for me to hire someone. But just to clarify,
sure.
We don't ask people their ID when they request records. We do require their ID or a form of ID to review the hard copy records, because we can't hand off public records to just anyone and then have them leave the room with it. And so they actually are assigned a room that is videoed to make sure that certain records don't go missing. And if they do go missing, we have a paper trail as to who may have taken them. That's the only purpose of that.
Okay, but I'm just letting you know that requesting ID as a condition of reviewing public records is not...
That's a department procedure.
And that's not permitted by the Public Records Act or the Sunshine Ordinance. So you want to check with your city attorney on that?
I'll double check with that, but I don't believe that to be true, to be explicit in order to review public records. I think it's quite common for people to turn over a form of identification to review public records. And the whole purpose is basically safekeeping of those records.
I understand your purpose, but it's not common and it's not permitted. So you'll want to look at that. I mean, if I request records either to review or to copy from other departments, I'm not asked for an ID, and that's... All right, I've said it. There you go. So just to recap, if you develop these policies and procedures, if you would be able to share those with us as a draft, we would be interested in that. That was the purpose of creating this item. I understand your interest in training new employees now and having that be part of their training as new people join the department. Did I understand that Kelly Amder was back doing that training function, or is she doing something else?
She is, she's been overseeing the new permit tracking system implementation, and since Joanna's left, she's also taken on the role of the communications manager during this interim period.
So who is the person largely responsible for training? Because there was a time...
Diana Sokoloff has taken on that.
She's got the training function now, okay, which Kelly was doing for a while.
Years ago,
or
yes.
a version of it.
Yes.
Okay, so Diana's now the person. So you were working with Diana on the public records and Sunshine component
It's training on actually the planning department functions, so it's top to bottom training that's long overdue.
Okay, so that's what she's on that, and you're including this piece in that.
Yeah, my component is the Planning Commission, Historic Preservation Commission, Sunshine Ordinance.
Got it, okay. So in the future, again, as people join the department, they will go through a day-and-a-half training, and one of the pieces will be when someone says, I'd like to review that docket, here's what you do, here's how that works, here's who you ask, here's how it gets logged.
That's right.
Okay, good. Okay, I think I'm pretty good. And again, when you have draft policies, please share them with us. We would love to see that. Member David?
Welcome. Looking forward to. I appreciate your sincere willingness to try to improve the sunshine at the planning department. So, looking forward to working with you. Thanks.
Member Fisher?
Just remember, we're the good guys here. You know, we're trying to make them happy. We're trying to make everybody happy. We're kind of, you know, we're the people here. I mean, look. The reason we're here is so people get their rights, so people get what they need, so they get what they're entitled to. And, you know, I just like saying we're the good guys. That's all.
I appreciate that, but I also hope you appreciate that when we come here, the automatic allegation is we're the bad guys, and we're trying to do something to circumvent someone's process.
There's no
the
good
reality
guys and
is,
bad
I think that's the
guys.
furthest thing from the truth.
No,
And
on
I'd like
that side,
I'd like
there's
to
no
make
good or
that.
bad.
I'd like to make that clear.
Yeah, I know. There's no good or bad on your side of the podium. It's, you know, people have needs. We're here to get them done. That's all I got.
Great. And as you know, we've talked many times, and I talked to lots of people in the department on a variety of matters on a, you know, at least a weekly basis, if not, you know, almost a daily basis. So my level of satisfaction is pretty good, but there are always things that we can tweak. And I think, you know, last year we went through a lot with Chapter 31 and environmental review, and I think, you know, there were concerns about that, but ultimately I think that got better. And so, you know, this is just another thing that we're working on. You're in a new position. You're getting staff to support it. And so we can, you know, continue to make this better. So I guess I still would like to see written policies and procedures, and I'm inclined to continue this to the call of the chair so that we can you know, see that when you have that created, either as a draft or when it's in force, or both. Because we have had a number of complaints and concerns about the department over time, whether they're well-founded or not, whether the people are more or less rational or not, whatever their issues about the projects, we still want to have, you know, good and clear procedures. And planning has an important role in the city, has historic records going way back, has lots of, you know, neighborhood concerns and rights implicated. So it's not a minor league operation, and I know that you take seriously your responsibilities now as Director of Commission Affairs and this record retention and custodian of records function. So that's my inclination, is to continue it so that we can see that in the future. You have no problem with that?
I don't have any issue with that.
Okay, and so when you have that, if you can let us know, that would be great. Is there, let me see if there's further public comment, and then we'll...
Thank you,
act on it.
Commissioners.
Thank you. Public comment?
Thomas Piccarello, just a couple of thoughts. Number one, you are the Outreach, Education, and Training Committee. Perhaps one of you, could go to the Planning Department and, give a 2 or 3 hour seminar on the Sunshine Ordinance. That perhaps might be helpful. It also would have been helpful to get a tentative compliance timeline with these promises as what the Planning Department is going to do. The Sunshine Ordinance is, 20 years old? And the previous speaker is telling you that there's really no policy or protocol in complying with the Sunshine Ordinance at the present time. If there was, he would have produced the documents tonight. But most importantly, I think somebody on the Outreach Committee perhaps should go to the Planning Department and educate them regarding the Sunshine Ordinance. Thank you.
Thank you. Further public comment? Mr. Pitts?
I looked at part of that document and it was a big red flag to me. My study of Illinois law and my study of San Francisco Sunshine Ordinance, I don't think you can say 2 weeks. I just don't think it's appropriate. I think it's good to say 5 or 10 business days. And what happens when your 2 weeks fall under Christmas, New Year's? So those days are almost lost. So that's the best practices for me. And then the other thing about it is he spoke about relevant or versus unrelevant information to some extent. And for me, who's the appropriate person to make that judgment? What he thinks is unrelevant, I might think very relevant, as in trying to put together information. For me, most of the time, I'd say some of these complaints are really basically about respect. And sometimes it's not even about the information, because we want the information when we're requesting it, and we want meetings to be run in a professional manner, in a legal manner. So I just think it's, he wants to say somebody's trying to demonize him and his body. If he just follows the law, then there's really nothing we can say. We can be outside yelling, but we can't bring it in here because there's no legitimate claims. So all he needs to do is follow the law. All the laws are online.
Thank you. Great. Is there any further public comment? Seeing none, public comment is closed. Can we continue this to the call of the chair without objection? We don't need a motion on that? Okay. So continue to the call of the chair. And we'll do that without objection. Thanks, Jonas. He's gone like the wind. All right. Item 5.
Item number 5, Administrative Code, Chapter 12L, Public Access to Records of Meetings of Nonprofit Organizations.
Okay, I didn't want to take too much time on this because people have to go.
I've got a few questions, though.
Oh, okay. Well, let me just give you the brief background. There's a draft memo in the packet.
Is that all right?
What I wanted...
Write that, or did you just cut and paste from a lot of stuff?
I wrote the first 4 pages of it, and then the rest of it is just the language of the law.
You have all that stuff in your head?
Yes.
Okay.
Sorry.
You have a head?
Yeah. Anyway, what I would like us to do is to authorize sending a slightly tweaked, but not much tweaked version of this to department heads and to others to seek their comment. It's merely a draft for which we are attempting ultimately to provide guidance to city departments and others on our interpretation of 12L and what it means.
I have two really short questions.
Yeah, okay.
So I have two questions. One, from what you just said, you want to share this with city departments, et cetera. But this is targeted towards nonprofits that receive at least $250K. So are we also going to share this with those nonprofits? And the subset, corollary to my question is, could we somewhere get a list of who those are?
I have been working on that. That has been taking a lot of time.
Oh, okay.
One of the big issues here is how you define, not how you define a nonprofit, but how you define a nonprofit organization that's subject to the ordinance, because it's $250,000 in funds received for providing direct services, but not other things, and they have to have at least one contract with the city. I mean, if you read through it, the concept is great and makes a lot of sense. The details and the when they're subject and when they're not and who does what gets very murky. And so that was the whole point of this exercise, is to try to provide some guidance on that. Ultimately, yes, it would affect the nonprofits, but we first wanted to start within the city family and try to figure out what departments are doing or not doing, and how, and their input, which is why we heard from Dave Curto from Human Services, which has the bulk of the thing, but there are lots of others that are involved too. There are at least two different city groups, the Joint Monitoring Steering Committee and the contracting brown bag something, whatever. So I'm supposed to go to two of their meetings in the next month or so and talk about this. They're all concerned about it. They all want to make it work. It's been on the books for 15 years. And again, they want to make it work, but it's complicated. These things often are. So that's where we are with it. Do you have further questions?
No, I always thought that it would be more straightforward. I used to be on the board of an organization that probably got about 250 in various different sundry ways and were active. So this means, but they fulfill most of this. Board meetings are open, members are public, et cetera. Just to be crystal clear, it's probably rhetorical, it doesn't mean that they're subject to sunshine. Like
No.
you couldn't come and make a complaint
They are
against
not subject
Youth
to-
and Children's Services, blah,
They're
blah, blah.
not subject to Chapter 37. They're
Right.
subject to Chapter 12L, which has different and very specific requirements for nonprofits, and the city in monitoring the performance of these nonprofits has a checklist and says, here's what we check for, da-da-da-da-da. So one of our things may be input to that checklist and say, well, you're asking for the minutes of the meeting, but maybe it's not the minutes that matters, it's the notice, and when did the notice go out? So are you keeping
Okay,
a
so
log of the
what
notices?
do we, in the interest of time, what do we do next?
It's to authorize that this,
Do you need a motion?
yeah, but
Okay.
let's take public comment. Why don't we take public comment first? Because ultimately, it's going to be a motion to authorize this as a memo.
Could the clerk reiterate the motion that's
We
been...
haven't made it yet.
We haven't made it yet, but would it be helpful if we make the motion first?
Yeah, I would.
Great. So, discussed.
Mr. Member, have it? Yeah, go ahead.
I'd like to make a motion to send out the draft letter to department heads and any other appropriate officials, as we deem, to get feedback on the proposals that Chair Pilpel has put in the letter dealing with how to comply with Sunshine Ordinance. How's that?
Feedback
second
on
that.
12L guidance.
On 12L, excuse me, I apologize.
No, that's good.
Specifically on 12L guidance, which is public access to records and meetings of nonprofit organizations. Sorry, yes, thank you.
And that's all we're doing
Right.
today, and we'll
To
have
send
further
out the
discussion
letter
about
for
it.
comments back. That is what the motion is for.
And I leaped too soon, but I will now officially second that.
All right, so we have a motion and a second. Public comment, Mr. Piccarello.
Thank you. So the letter then is the one in your agenda package, page 243 to 251? Is that the letter, or there'll be a separate letter with
It'll
the
be-
memorandum attached there too?
No, it'll be remarkably similar to this. I'm going to clean it up a little bit because there were a couple of things I wanted to change, but it'll be remarkably similar to this.
Yeah, okay. Well, initially it's hard to comment on something that's going to happen in the future, but let me comment on I'm looking at it tonight. First of all, it would have been helpful to members of the public in this draft for you to give examples of what you're proposing to change. This draft is not very helpful. It's very difficult to read also because you write the word draft across the entire page and it's almost like a redaction. You have to search for some of the language in this memorandum.
You could make that more
I
transparent.
apologize. That was the way it printed. That was not my intent.
Okay, I get 10 more seconds as a result of your apology. There should be a more fundamental threshold question, and that is whether or not nonprofits should have their own quasi-sunshine, 12L. Why should nonprofits be any different than other city departments? That should be a discussion that should have been held before you are making these proposals, changes. And again, it would have been helpful for you to underline what you're seeking to remove, delete, or add, so that individuals could then make give better opinions as to these changes. And finally, my question is, what prompted this? And whose work product is this? Is this a work product from the nonprofits or simply the work of the chair of this committee? With all due respect, if it's just the chairman's ideas, you don't have a monopoly on wisdom. You should get input from other people before you start attempting to modify 12L. All right? Thank you.
Thank you. Comment in a moment. Mr. Pitts?
Well, if anything, I think the 12L law is more of an exemption from the Sunshine Ordinance. I have several serious issues regarding some of the things that I've experienced. Not allowed to record public meetings, kicked out of public meetings in which they've called the police and I was threatened by the police and kicked out of a meeting. Not given information such as parts of their budget of which they said they would give me, I have not received. It's just several things, and when you go under the 12L laws to request remedy from the Sunshine, it seems like they'll go to, we don't have the information. And of course, chances are very high they don't have the information, but it seems like they don't understand what their role is in regarding remedying this. And then the next step of that is that you're supposed to go to the Board of Supervisors under 12L to seek remedy from the service provider and the governing agency, the governing city agency. So will the Board of Supervisors make time for that when the other bodies are not doing it, and it's on many levels a willful non-wishing to comply? It just really feels like an exemption for the nonprofits, and they are going to create rules and regulations that are in direct opposite of what the Sunshine Ordinance would say, because Community Housing Partnership says you can't record. If you try to come 15 minutes later, then you're not allowed into the meeting. So consider how that would work if it was a city government body. You come 15 minutes late, you're not allowed in. So what happens if you leave and then you come back? Now you're not allowed in. And then it just gets worse. It gets worse. They get exemptions from the Sunshine. They get exemptions from the rent board. It's really like an oppression of the poor and impoverished. I'm just wondering what happens when I start to request minutes from previous meetings. Some of the people they have no type of understanding of basic functioning of government, as they don't even know how to take minutes or even how to put together an agenda, some of these people. So these not-for-profits really need some training into basic functionings of government.
Thank you. Okay, so just to respond very briefly, and then we got to move, because we got to move. The Board of Supervisors passed this as an ordinance in 1998. There was a lot of discussion at that time about balancing the interests in public disclosure and the interests in privacy of nonprofits and their operation. So that policy discussion has already been had. The law is the law. We have a role in offering advisory opinions when requested under 12L.5. So all I was attempting to do was to provide some guidance where there is some ambiguity, in part in response to complaints that Mr. Pitts has made, where Human Services or other departments are supposed to have procedures to address those concerns. As to tenant council meetings and other sorts of things, those are not covered. It's only meetings of the board of directors of the nonprofit. And so we weren't actually adjudicating any particular complaint. This was trying to be, again, looking at the large role of the task force and provide guidance on interpretation of the law. So that's the overall. We have a motion before us, and by the way, if either one of you or anyone else has any substantive comments on this, be very interested in receiving them. Feel free to write that up, get it to Victor, and we will see those, because we will discuss this in the fullness of time.
I just have one question.
Sure.
Does your word processor allow you to track changes on your draft?
It does.
So could you, any changes that are made, could you track changes so this way we can...
Yeah, I can get that to you. The letter will go out as a final letter.
Exactly. Yeah, that's what I'm saying. But just
For example, there are occasions, a couple places where I said we've got a list. I haven't yet developed the list because I'm still going through the controller's information, et cetera, et cetera.
I have no concerns. I'm just all I'm saying is that I think that in the to err on the side of sunshine, tracking changes I think would be a good way to deal with people's concerns. That's
Got it. Okay. We have a motion and a second. Let's take a roll call on that.
On that motion, Member David?
Aye.
David, aye. Member Fisher?
Aye.
Fisher, aye. Chair Pelpel?
Aye.
Pelpel, aye. The motion passes.
Great. Thank you. And I will try to get that letter out along with the other correspondence that we've got. So that's item 5. Let's go on to item 6 very quickly, because we're about to lose our quorum.
Item number 6, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction, but not on today's agenda.
Is there further public comment? And can we limit this to 2 minutes?
I'll be brief. I was just curious, the history. There was an item on your agenda several weeks ago for tonight. It regarding public comment on the city budget. I believe there was a complaint filed by...
I'll address that under item 7. I got it. It hasn't disappeared. We'll talk about it in item 7.
Oh, okay, fine.
No problem. Thank you. Mr. Pitts, anything on general public comment? Great. Nothing further. Public comment is closed. Item 7.
Item 7, announcements, comments, questions, and future agenda items.
Okay, so the item about public comment at Board of Supervisors Budget and Finance Committee, we did find a violation in November or December. There has been a letter or an order of determination sent. We're supposed to have that here in February, not January, because we were waiting on the new committee assignments. As it turns out, the Budget and Finance Committee did not change, but we wanted to see, we didn't know at the time. So I've already got a call into Catherine Stephanie of Supervisor Farrell's office, and I would expect to have her or someone from Supervisor Farrell's office here for the February meeting to talk about public comment on the budget for the upcoming budget season. So we got it. it's in the queue. Further, for next time, some combination of that, the task force website that we talked about last in November or December, I think? I forget now. The city attorney letter, if there's a response, although I suspect that we may not get a response for February, so that may be March. But I've got that in the queue. The planning department procedures, in case we get something back on that. 12L is a continuing item. So those are the big things that are currently before the committee. Victor, is there anything I missed?
There's nothing else that I recall.
Okay. Member Fisher? Okay. And who knows, after the February meeting, we may have further things referred from the full task force, but likely not from February 5th to February, 10th?
I'm unsure.
Yeah, okay. Anyway, so those are the things you should expect at the February meeting.
February meeting?
Victor's about to check. I think it's February 10th. If it's the 5th, then it would be the 10th. But it won't
Is
be
the second Tuesday?
Second Monday.
I'm sorry, second Monday, so that is the 10th then. Okay.
And you're good to be on the committee, like as a real, okay.
I'm on the committee.
We would need to get a reappointment.
Okay. It was only for
Fisher
today.
was only appointed for.
You're only appointed for today, but if you're having so much fun, we can have you back on a regular basis. Would you like that? Why don't you think about it?
Let me talk to Chair Grant about it.
Okay, cool.
Should be okay.
Okay, so those are the things I have in the queue. Is there anything further on item 7? Did anyone else have any new items? No. Member Fisher? No? Okay. Is there any public comment? No? Again, 2 minutes?
Well, I would appreciate it if you were to send information regarding your budget scenario to some of the other bodies, such as the Shelter Monitoring Committee and the Local Homeless Coordinating Board and the SRO Task Force. Some of these bodies are trying to limit public comment to like 1 minute, and it's I think if they don't correct it, then it gives me probable cause or a legitimate claim against them.
Fair point. Thank you very much. Local Homeless Coordinating Board this Friday at 11. You know the meeting date. Sorry? Local Homeless Coordinating Board this Friday at 11 is their meeting. Okay.